Let's try that again. Oh Lord, live video. I'm the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal lawsuits to enforce the Affidavit of Support. And today I wanted to talk about something that comes up pretty often in my consultations, which is, what do you do if you are a sponsored green card holder and you are under the impression that the defendant, the Affidavit of Support sponsor in your case, doesn't have any money? Now, these lawsuits are fundamentally about one thing, and that is recovering money from the sponsor. They're not about getting even. They're not about custody. They're not about getting back about things that happened in a relationship. The only thing that a federal judge can give you as the plaintiff in one of these lawsuits is money. So why would you go into the lawsuit if you are under the impression as the plaintiff, as the person bringing the lawsuit, if you're under the impression that the defendant doesn't have any money? 5 reasons why you might want to consider it anyway. Number one, you don't really know going into a lawsuit what a defendant's financial situation is. Now, most of these Affidavit of Support lawsuits are one spouse against a current or former spouse. And so folks often think that they have a pretty good understanding of the opposing party's financial situation. I will tell you that there are often surprises there. So you can't really assume that you have a clear understanding of all of the savings and investments that a defendant might have until you get into litigation and are involved in the formal discovery process. Discovery in the process of immigration, in the process of litigation, refers to the formal exchange of information. So through the discovery process, one of the things we will always do is get a clear understanding of what liquidity, what financial savings the defendant has. And there are often surprises in that. So number one, you don't want to proceed or not proceed into litigation simply because you're assuming, without having done real investigation, what the person's actual income is. Number two, in Affidavit of Support lawsuits, you may have a co-sponsor in your case. Now, a co-sponsor, also called a joint sponsor, is somebody else who would have signed an additional Affidavit of Support in addition to your sponsor. Now, again, you may think that only the primary petitioner in your immigration case, which in most cases will be the spouse or fiance, you might think that was the only person who signed a binding Affidavit of Support for you. But it, again, happens more often than you might think that after we begin working with a new client and file a Freedom of Information Act request, which we do in all of our cases, when we get that file back from immigration, we discover, for various reasons, that the petitioner got a friend or a family member to sign an additional Affidavit of Support. And the primary reason somebody would do that is if they are low income. So in a situation where you have that flag of thinking, hey, the sponsor is relatively low income, that is the type of case where we would expect, with a reasonable degree of likelihood, that there might be a joint sponsor. So until you do your due diligence and request the immigration file from USCIS, you don't know for sure whether or not there was a joint sponsor. We may as well go through that investigation process. There's no cost to filing a Freedom of Information Act request. Number three, even in a situation where a defendant doesn't have savings and there's no joint sponsor, in a surprising number of cases that I've worked on, the defendant will find a way to get a loan or get money borrowed from friends or family members to pay off either a judgment or a settlement agreement. This happens more often, again, than you might think. We have had cases that go well into the litigation process with the defendant saying all along, I don't have any resources, I don't have an ability to pay a settlement. And then as the case progresses and progresses, suddenly, out of the blue, a loan comes through from a family member and the case gets resolved overnight. this happened more than a couple times last year in 2022 alone. So again, until you get into the process of litigation and you put some real pressure on the defendant, you don't know what family and friend resources or just lending institutions that defendant may have available to them to get the liquidity that they need to pay down a judgment or to pay a settlement agreement. So that's number 3. Defendant may have the ability to take out a loan. Number 4, in terms of reasons to go after a defendant who may appear to have no money, time limitations for bringing your claim. Now, this is an area that is very unsettled. Legal claims in the United States are generally, although not always, subject to something called a statute of limitations. What this means is that if you punch me in the face and I want to sue you for the tort of face punching, I have only a set amount of time. It varies by state. Usually it's something in the area of 3 years to come back and sue you for the face punching. If I don't do that, then the claim is lost and I can't do it. Now, affidavit of support claims are tricky because the statute that created affidavits of support does not define a time limit for when you have to bring the claim. There is a strong reason to argue that there is no statute of limitations, and there just is no deadline for bringing a claim under the affidavit of support. But to play it safe, I always encourage people to think strategically that the statute of limitations applicable to written contract disputes may apply in these cases. Depending on your state, that's typically between 3 and 6 years. So conservatively, just in case a judge were later to determine that a 3-year limitation or a 6-year limitation applies to your claim, the conservative and safe thing to do is to go ahead and file and litigate that claim, even if you think the defendant might effectively be judgment-proof at the time, which means just doesn't have any resources. On top of that fact, the fact that you might want to be careful about statute of limitations, claims under the affidavit of support have been determined in the only cases to consider the issue, considered to be bankruptcy-proof, which is to say exempt from discharge. This means that even if you get a judgment and the defendant later files for bankruptcy protection, courts have determined that the type of debt that you have in that situation as the sponsored immigrant is something called a domestic support obligation. It's like alimony. And for that reason, under the bankruptcy code, it is exempt from discharge. And even if the sponsor goes through the bankruptcy process, your claim and the liability that it represents is going to survive and you can continue to collect it. So that's number 4, the 1-2 consideration of statute of limitations and bankruptcy protection. 5th and final reason to consider proceeding against a defendant who doesn't seem to have any money is effectively, why not? If you work with a firm like mine that does these cases without charging upfront legal fees, and that's what we do, we don't charge our clients any out-of-pocket legal fees. We recover our fees exclusively from the defendants in these lawsuits. That means they are very low risk, financially speaking, to our clients. Now, there is work involved. You are going to have to put in some time with your lawyer to advance your claim, but you aren't out of pocket. You aren't paying money into this process of securing a judgment or settlement against the defendant. So it's relatively low risk from that perspective. Instead of being in the pickle of having to pay, $10,000 or $50,000 out of pocket to proceed against the defendant, it's actually your lawyer in this sort of situation who assumes the risk. When I am representing a client in federal litigation, it is really me investing my time and experience in that litigation anticipating that we will indeed be able to successfully recover against the defendant down the line. And that's because I'm very confident that we will be able to ultimately recover from the defendant. So again, that is a risk that's assumed by the law firm. It's not assumed by the client from a financial standpoint. And so that's a fifth strong reason to go ahead and proceed in these cases, is that you as the affidavit of support beneficiary are not assuming a significant financial risk in bringing the case. Hope that's helpful. If you have questions about the affidavit of support, feel free to drop them in the comments. If you would like a confidential case assessment about your potential claim under the affidavit of support, we work with clients all across the United States and do Zoom consults every day. Happy to chat with you. Reach out to us on our website. Hope that's helpful.